my lords. May I just pick up 3 points from yesterday? First of all, my Lord Briggs asked the question, when was the guarantee reneged on? That was in the context of a part of the transcript that Lord Hughes had referred us to yesterday. The evidence from Mr. Al-Sadik, because it was in the context of Mr. Al-Sadik being asked questions, only when they reneged. So what did he mean by that? Was your question to me. Question. Could I take you to see the core record documents, volume 3, tab 15, which is Mr. Al-Sadik's witness statement. And I think one of your lordships said this, I think maybe my Lord Reid, said it was December 2008. I said I didn't know. It's 1374. And if one looks at... Sorry, I don't know if Lord Briggs is plugged in.
I am.
You're obviously plugged in, but I mean plugged in your for the transcript.
I'm plugged in every possible way.
Exactly. Didn't want to be disrespectful on the transcript. Para 97 which is memory stick 1374, and I think it may be that's what's being referred to.
That's December 08.
Exactly. That's when there's a clear letter to the effect where there's no guarantee in relation to it. Secondly, Lord Sumption asked me, and you've got the transcript in front of you from yesterday, page 146. You asked me about could they do 3 times on top of 3 times in relation to LDSF, and I said, I think they probably would. I made the point about non-recourse. I just add to that answer, not in any way detracting from it. Remember, there's a duty of care. You've got to use reasonable care in making the investments, which would be implicit in the arrangement. You might well have authority to do something, albeit that it might be careless. If the levels of leverage got incredibly high, that might be careless, but it might well be within the authority. And then, I don't know if your lordships have got it, but I was sent yesterday evening by my learned friend, Mr. Black, this document, which is an analysis of the Court of Appeal's discussions, various remarks the Court of Appeal made, not in the judgment, but in the hearing, which it is then contended by Mr. Black were not then followed up in their judgment. And I was also sent this document, which is a 6-page summary of, I'm holding it out like a sort of selling a shopping channel. I don't know if you've got that.
I think so.
Yes. Okay. I haven't got the previous one, but I've got that.
Have we got both together, Mr. Black? Both bound together?
Yes, that's what
we've got both those documents.
Yeah, yeah. I don't want to sound like a sort of whiner in court at first instance, but to produce 2 documents after you sat down in the Judicial Committee of the Privy Council is pretty rum, I would respectfully submit, to make points like that at that late stage. But you know,
I'm afraid we don't quite know what's in them.
Well,
when did you get these?
I got
documents?
these. I got them at about 6 o'clock yesterday evening, personally. But they may have been delivered between 4 o'clock and 6 o'clock. So they may have arrived at 4:30.
As I understand your summary of them, and it's consistent with what Mr. Black said to us yesterday. This is essentially a list of occasions when interventions in the course of argument were not reflected in the final judgment.
Correct.
Which is a routine peril of oral hearings.
Indeed. And, I mean, just to take the first one, which is the famous new contention, I was arguing it might be a hedge fund product. That's paras number 1 and 2. If one just goes to the Court of Appeal at paragraph 67, which is in flag 4 of the core bundle, page 163, just to sort of slightly explain that what this document is seeking to show is, look, there was a discussion with Lord Faulkner about was it a hedge fund product. The Court of Appeal then fined at para 67, as I have said, the logically anterior question was whether the transfer of funds from Charlotte to Blossom was an administrative step taken in contemplation of the investment of those funds and was not itself to be treated as an investment of those funds. If, as the judge held correctly, in my view, the answer to that question was yes, then the question whether Blossom itself was an investment hedge fund, Investcorp hedge fund, or a hedge fund or segregated account with any other hedge fund managers did not arise. So that's why they didn't deal with the points that had been discussed with me in the course of argument. And to say that that indicates that they hadn't properly considered the oral argument is, in my respectful submission, unjustified.
I vote we put aside Mr. Black's new documents for the moment and see what he seeks to make of them and whether he's entitled to make anything of them in reply, Lord Faulkner. But you've put down a marker.
My Lord.
Very well, yes.
I'm happy to deal with it on that basis. My Lord, could I then go back to the main body of my submissions? My Lords, unless there is any point that you wish me to deal with on construction, I only want to make one very sort of subsidiary point in relation to construction, and that's both in relation to Blossom and in relation to unauthorised leverage. For the reasons I submitted yesterday, I submit it's well within the discretion to do what is desirable or necessary. As long as it is for the purpose, then it's within, as a matter of commercial common sense, that's the right construction. I also say, in relation to commercial common sense, if it would flout commercial common sense, which is a stage further, I submit, than simply which of two constructions is better, then the court should come to the one that is consistent with commercial common sense. And I get that from the Rainy Sky, Lord Clerk of Stonecombe-Ebony's judgment. The only other point I would make is this, that in the Rainy Sky, Lord Clerk of Stonecombe-Ebony says the court, meaning the Court of Appeal and either the Supreme Court or the Judicial Committee of the Privy Council, is entitled to take into account a view that an experienced commercial judge has taken of a document. That's at paragraph 41 of the Rainy Sky. I don't ask you to look it up. Mr. Justice Jones is an experienced commercial judge in the Cayman Islands, particularly experienced both in his practice and as a judge in dealing with structures such as this. And if you look through the judgment, it's plain that he is very well acquainted with SPVs and this sort of hedge fund structure. Now, it's not a point that decides the case, but it's a point that your lordships are entitled to take into account. And in my respectful submission, it's a point that is of some significance in determining whether or not one's going to go for a construction rejected not just by Mr. Justice Jones, but a Court of Appeal, both experienced in that area, presided over by a very experienced Chancery judge, therefore well experienced in relation to corporate structures.
Those points are fair. I mean, basically, we want to look at this for ourselves within the limits of this appellate review.
Exactly. And
so I don't think we would want to attach too much significance to respect, however much deserved, on the part of the trial judge, if you follow what I'm saying.
Absolutely, I completely follow that. And if your lordships took the view that this was a plainly wrong construction, the fact that it was made by an experienced commercial judge would not be an answer to it. But it is, in my respectful submission, so obviously a correct construction, both in relation to Blossom and unauthorised leverage, for the reasons I've indicated, that I would respectfully submit that your lordships would be entitled to treat that as a further indicator that the construction is right. My Lord, could I briefly deal with the questions of loss and damage? And in my respectful submission, you have to look at the loss and damage pleas that have been run separately. First of all, in relation to the claims of unauthorised leverage and unauthorised investment. That's Blossom on the one hand and first layer leverage on the other. That is one category, and then the other is the breach of F4. At first instance, the judge in effect did not draw a distinction between the Blossom breach and the first layer leverage breach, in my view, correctly. The Court of Appeal did draw such a distinction. They approached the two differently, see powers 126 and 127 of the Court of Appeal's judgment. In my respectful submission, that was wrong, and as I understand Mr. Black's submissions, he now accepts that that was wrong and deals with the two in the same way. And, my Lord, one gets that from page 96 of the transcript before your Lordships yesterday, lines 12 to line 15. If I may deal first,
yes.
He treats the two the same. He drew no distinction in his submissions yesterday, and he expressly said that there was, and that in my submission is, irrespective whether he's conceded it or not, correct. And the right way for your Lordships to look at it is to say, what would have happened factually if there had not been the notional breach? I say there was no breach, but you have to assume that there was a breach, either in investing in Blossom, the transfer of the money to Blossom, or using leverage at the Blossom level rather than at the branded fund level.
Do we not have to take, bearing in mind that it's not in dispute there was a breach of the disclosure requirement?
Yes.
Do we not have, for our purposes, on the assumption there may have been a breach of the Clause A or the borrowing requirement, have to look at those together rather than separately?
Well, the way I submit that you
because
look at
one has to ask, what if there had been no breach, but performance would have been the difference in your client, in the appellant's position?
I submit the correct way for your Lordships to look at it in relation to the leverage or authority breach is to say, assume that there is a breach, assume that F4 would have been complied with, what would have happened? I say that you're entitled to take into account what happened in relation to the breach of F4 in determining what would have happened had he been told of it.
I mean, do you presumably accept that if there had been clear evidence that provided with proper information on the monthly reports, he would forthwith have redeemed, that would be relevant to the measure of damages?
Of course, that's right. Assume the position, yes. So
that would be so, as it provisionally seems to me, whether the cause of action was fraud or just bog standard breach of contract.
Correct, I agree with that. But what I'm only dealing with the breach of authority claim here. I think the right way, I submit the right way to look at it is assume compliance, what would have happened? Well, he'd have invested in, Investcorp would have invested in LDSF and SMFCO. Assume as well compliance with F4. He's contractually entitled to that. What would then have happened? The counterfactual, in effect, now being advanced, is had there not been the investment in Blossom, there would have been the investment in LDSF and SMFCO. Assume that he had been told about that in accordance with F4. He then would, I don't know what quite is being said, but I think what's being said is he would then have redeemed or treated the whole thing as a dreadful repudiation or something. That is the case that's being advanced. But I am accepting, for the purposes of the argument, that when you're looking at the breach of Clause A, as it's put, you then assume compliance with F4. Because otherwise, you can't escape the consequences.
Otherwise, you won't find out.
Exactly, that's right.
But it's compliance with F4, by the disclosure of, in fact, on the hypothetical, a different investment pattern.
Exactly, that's right. That must be
Yes.
the counterfactual, in my respectful sense.
So you assume no breaches down the line?
Absolutely.
Yes.
And then you ask yourself, the counterfactual is, so you assume, what would Investcorp have done? Answer, what Investcorp would have done, according to the judge, and this is not challenged, is put it into LDSF and SMFCO. What would he have then done when told about it? He says, I'd have immediately redeemed or done something. Now, that is the right approach, and unless you want me to, that's my Lord Reid in one step, and it's Lord Justice Patton in Durham, and Lord Justice Toulson, as he then was, in Durham as well. And I don't think there's much dispute about that. That's the approach, and indeed it's the approach reflected in their submissions. The problem for my learned friend, Mr. Black, in relation to it, is that's the counterfactual for the breaches of authority that he's got to establish. He never pleaded it. I don't ask, look at CR Core Record Documents, Flag 1, page 380. He never advanced a case in relation to it in evidence. And it is absolutely implicit in the judge's finding that once he's found that LDSF and SMFCO would have been the alternative investments, of course there wouldn't have been any redemption by Mr. Al-Sadik in relation to it. In the language of, I can't remember the name of the judge who says, when you're talking about implied terms, it goes without saying that of course he wouldn't have redeemed had that been the position. And in support of that, if I could just take you to the judgment, two bits of the judgment. First of all, 520. If you go to line 23, this is memory script page 98, sorry. Furthermore, if he had been fully, this is dealing in fact with what would have happened if he'd been told it was Blossom. Further, if he had been fully informed in March or April about the way in which Investcorp intended to leverage the investment, that's Blossom, I find it difficult to envisage why he would have objected in principle to the use of a limited recourse credit facility offered by a bank, but accepted an investment in LDSF and SMFCO when the two approaches were intended to achieve an equivalent economic result for him. Now, although he's dealing with the Blossom point there, it's absolutely implicit in that it's his view that had it been LDSF and SMFCO, that Mr. Al-Sadik would have accepted that. And it exactly reflects the point Lord Sumption made in the hearing yesterday. Surely the judge is finding, in effect, that once it was LDSF and SMFCO, Mr. Al-Sadik, would have accepted that. And the answer to that is yes, he absolutely would have done, because what the judge is saying, in effect, is I doubt, even if he'd been told it was Blossom, that would have made any difference. Because obviously the starting point from that conclusion is, well, obviously if it was LDSF and SMFCO, that wouldn't have made any difference. So the judge is almost certainly making that finding, but go to 6.6 as well.
Well, just before you leave that,
sorry,
I think no, not at all. But while we've got it in front of us, I think what's being said is that the complaint is that he hasn't really asked himself whether he would have objected in principle.
Well, the answer, it is necessarily implicit. I mean, I take that point, but I submit it is necessarily implicit in that conclusion that there, quote, wouldn't have been any question had it been LDSF or SMFCO that he would have stuck with it. But, I mean, that's my submission.
Yep.
6.6.
Because that would have been perfectly in line with the investment proposal.
Exactly. I mean, I'm dealing with, in this submission, actually the judge has in effect decided this already. He just thought it was so obvious Nobody was suggesting the contrary at the trial. There wasn't an issue in relation to it. It just went without saying, as it were, although he did in fact say it. And 6.6,
Page?
memory stick 105,
Yeah. Yeah.
this is the last three lines, line 21 to 23. During the negotiations, he appears to have been most focused on fees and liquidity. In the period after his investment was made until the market crash, he was focused only on the investment return. And that's absolutely consistent with what the judge, all he was interested in, this is reflecting the way that Corondi reported, give me the NAV, that's what I want to know. It's following that. It wouldn't have made a blind bit of difference to him whether he'd been told it was Blossom or LDSF. And the danger in appeals is you identify a point that nobody thought was remotely serious at the trial, and then you say, you blind the Court of Appeal or the higher court, saying, look, the judge never considered this. It's a point he was never asked to consider, and everybody understood it was hopeless. My Lord, just in relation to that, we were horrified at the thought of remission in relation to this. And this case has been going on for years and years and years. I mean, not through the fault of Mr. Black or his client, but the idea of remitting now to deal with a point that was never raised, that the judges almost certainly decided would be a horrific conclusion. So we would urge you, if you got anywhere near thinking that there was a point here, to decide for yourself what the answer was. But we say you don't get to that point because it's not pleaded. The judges decided it insofar as it was pleaded.
We understand all that, Mr.
I'm obliged, my Lord.
But Falcon, could you just help me on one aspect of that is slightly different from the one you're dealing with? The judge makes quite a clear finding at the end of his treatment of the Blossom stroke portfolio leveraging issue, that on a counterfactual that your clients had complied with the construction being contended for, they would have done a 50-50 investment in SMS and LBSF.
SMF Co and LBSF.
SMS Co and LBSF,
yes.
Yeah. He doesn't go on to say whether they would have left it there or traded out of it as the market turned.
Well,
it's a discretionary portfolio, as I understand it, where,
yes.
where the manager might be expected, if the market circumstances are much less propitious, for example, to try and deleverage.
Yes.
And that doesn't seem to have been addressed at all.
Because it was never suggested that deleveraging was a possibility, and throughout the period, no deleveraging takes place.
Well, a bit did, didn't it?
A bit did.
When they hit the loan-to-value limit.
That's right. But that was never in play as a possibility.
Right.
And I don't, in my respectful submission, if that was never in play factually as a possibility, then it's not for the judge to start inventing new cases.
Thank you.
My Lord, just the point, and I've said this so often that I feel embarrassed to say it again, it wasn't pleaded this point, and just Mr. Black in submission yesterday accepted at page 88 to 89, internal numbering, that it was for him to plead and prove the case on causation and loss and damage.
Didn't he ask for permission to come back on that, Lord Falconer? When he researched it more.
What he asked permission to come back on was he was amazed to discover, when you pointed it out to him, and I say this with respect, that the Court of Appeal had taken the view that the case on F4 had never been pleaded as a
purely contractual case.
Exactly, the F4 case, not the authority case. So I think it wasn't on that point that he came back. But
Well, he did say, could he answer?
he could reply on
I raised
that
the point. He said, could he reply on it?
Exactly, that's right. But that's a different point, I think, from the point that Lord Wilson is putting to me. If you look at page 80, bottom of page 88, and through to the question that Lord Briggs asks at line 7 on page 89. So he accepts it's for him to plead and prove the counterfactual that he relies on. He never pleaded it. He never sought to prove it. Remember this as well, that as time goes on in relation to this, he is alleging that he's got the benefit of a guarantee. And the guarantee is important in this respect. He's going to get a return of 45% guaranteed over 3 years. That's his case, a case that he continues to run before the judge, a case he continues to assert, although he abandons his appeal, because it's a factual appeal, the way that he seeks to abandon his appeal, if you just go to record 135055, he says, I'm abandoning it. But this is his counsel speaking.
Hold on, please, Lord Fulton.
Sure.
Vol 13.
It's record 135055.
Yes. Internal page numbering.
Page 2, line 18. This is Mr. Black talking to the Court of Appeal.
Yeah.
I'm struck that Mr. Al-Sadiq remains firm in his view that he was given such a guarantee, but on advice he no longer seeks to appeal from that aspect of the decision. So he is asserting, even after his defeat, that he has the benefit of guarantee. During this period, he says he's got a guarantee. He believes he's got a guarantee. Is he going to redeem when the market is going to hell in a handcart, when he's got the benefit of this huge guarantee?
A bit like having Lehman unsecured debt.
Precisely.
In a crashing market.
Exactly. But it goes much deeper than that. We know that the judge finds that he's told in October that there is leverage. That's 321 in the judgment. Just take your lordships to 321, which is page MS60.
Yes.
Could I just take Mr. Al-Khatib, that's not Mr. Al-Sadiq, Mr. Al-Khatib call notes record that Mr. Al-Sadiq was extremely angry and again compared Investcorp's performance unfavourably with that of Citigroup and HSBC, whose representatives were introduced to Mr. Al-Khatib as they were leaving the office, because Mr. Al-Khatib, who's our man, goes to see Mr. Al-Sadiq in his office, and his other hedge fund managers, HSBC, are just leaving, presumably after they've got an extreme whacking, because their funds are also going through the floor at that particular point. Mr. Al-Khatib's was introduced to Mr. Al-Khatib as they were leaving. Mr. Al-Khatib's response, this is to the extremely angry Mr. Al-Sadiq, was that Investcorp's performance must have been worse because of leverage, to which Mr. Al-Sadiq responded that everybody was leveraged. Mr. Al-Khatib was very clear in his evidence that there was a discussion at this meeting about the use of leverage as the explanation for relatively bad performance of the Investcorp portfolio in the market crash. His evidence is consistent with what he wrote in the contemporaneous call note, that's Mr. Al-Khatib of Investcorp. Given that Mr. Al-Sadiq had met with HSBC immediately before his meeting with Mr. Al-Khatib, it seems to be inherently likely that there would have been some discussion about the relative performance of the two portfolios, which would have led on to a discussion about Investcorp's use of leverage. I do not accept the evidence of Mr. Al-Sadiq and Mr. Sadik, who says he was present, although his presence is not recorded in the call note, that no such discussion took place, nor do I accept their evidence that Mr. Al-Khatib confirmed orally the existence of the guarantee. And then if one just goes to 514, the judge repeats that finding at MS 93.
Yes.
I'm also satisfied there was a discussion about leverage at the meeting. So he's told about leverage in October 2008, and he doesn't do anything. again, what we are dealing with here is the counterfactual. He's known, because we assume that he's been told under F4 that the money is in LDSF and SMFCO. He therefore understands that it's leveraged. His case is, I would have then done something to redeem or reduce my exposure. The evidence shows that he knew that. He knew there was leverage. The evidence shows that he wasn't interested in how it was done, and he didn't redeem. So his counterfactual that he would have redeemed had he been told about LDSF and SMFCO is nonsense, and it doesn't need to be rejected. It's simply enough for the court to say, well, it was never run because it was so fatuous. The judge is not to be criticised for not deciding it because nobody asked him to decide it, if and insofar as it was in play, he, by implication, has necessarily decided it. If in any way it's for the court now to decide it, it's hopeless and you should reject it. Those are my submissions in relation to both Blossom and unauthorised leverage. It is utterly and completely hopeless. My Lord, that's the position in relation to loss and damage in relation to unauthorised investment. Just as a final point, it's exactly what you would expect the position to be, because his complaint on this angle was you did it the wrong way, not that you did it. That you shouldn't have done it through Blossom and first-year leveraging. You were only authorised to do it on the basis of LDSF and SMFCO. If you find out, with the benefit of hindsight, that actually if you'd done it the right way, your position would have been worse, it would be a very odd conclusion that the law reaches that actually you get damages for doing it the right way, which would have made your position worse.
It would be like Target and Redfern's in the Court of Appeal all over again.
Exactly. That's right. So the facts and the law come together in a happy conflagration here. My Lord, those are my submissions in relation to loss and damage on Blossom and unauthorised leverage. F4, it is a different approach that is taken, sort of in terms of the counterfactual. In relation to F4, the approach to take, insofar as breach of contract, is to ask yourself the question, what would have happened had he been told about the Blossom structure? That is the counterfactual there, and you're not asking yourself about what would have happened had it been LDSF. Now, my Lord, in relation to how you approach this, I submit, before you even get to that all his case on F4 is now dead because he has failed on deceit.
Well, except for his contractual claim.
He has no contractual claim. He's not advancing a contractual claim. When you say except a contractual claim...
Except for a theoretical contractual claim.
Well, in relation to that, I say this. It was never pleaded as a freestanding contractual claim, and that is of significance because even though one might say, well, even though it wasn't pleaded as a freestanding one, all the elements were there. No, they were not, because when it came to loss and damage, what he sought was not loss and damage on the basis there would have come a time at which he would have redeemed. It's pleaded on the basis he wants the full amount back for rescission. So he was never putting before the judge a factual scenario that said there would have come a point at which I would have redeemed. And that is significant, because it brings you straight back to the guarantee point. Of course he was never going to say he would have of redeemed, because his whole point was I had a guarantee, therefore of course I would never have guaranteed. So it's important that. So he doesn't have a freestanding F4 breach of contract claim. Even if he did have a freestanding F4 claim, he never pleaded the damage he now seeks to recover.
Mr. Black made the ingenious and difficult submission, Lord Falconer. We now know that he didn't have a guarantee.
Yes.
How do you deal with that argument?
I say that you have to ask yourself, what would Mr. Al-Sadiq have done if he had been told about Blossom? Assume that we know that the court has found he didn't have a guarantee. Well,
it's more than that, isn't it? Because the judge didn't think that Mr. Sadik ever really believed he had a guarantee.
Yes. Well, he said there were, quote, increasingly disingenuous attempts to justify the having of a guarantee.
Yes.
He found him unreliable. He doesn't say he's a liar at any point.
Well, I mean, yes, it's a question of vocabulary, really.
Okay, a question of vocabulary. But he stands before you in the Court of Appeal through the medium of Mr. Black and says, actually, despite the fact the judge says that I didn't have a guarantee, I believed that I had a guarantee.
Yes,
How can you?
Well, whether you can sensibly do it or not is not the point. If you get to the question of what would have happened on the facts as they really were,
Yeah.
the judge's finding is that on the facts that they really were, nobody thought there was a guarantee.
Well, I don't want to parse that, but I don't accept necessarily the proposition. I mean, I am outraged on behalf of the justice system that somebody can come to this court and say, I believe I had a guarantee, but I'm asking you now to treat me as if I was lying about that. Because that's the only...
Not all that unusual to reject the evidence.
No.
And then to say, now we've established the real position, let's see what would have happened.
I see that, but there must be some element of acceptance.
But you have to have some sort of evidential basis for that he would have done A or B.
I'm making a threshold point.
But, I mean, your better point surely is that we should not interpret, unless it's very clear, his somewhat equivocal evidence about whether he would have redeemed as suggesting that he would, since it was inconsistent with the whole tenor of the rest of his case.
Yes.
So the fact that there are the odd sort of half sentences here and there around the transcript which might support it shouldn't have much weight.
Plus, I suppose you say what he did, in fact. Sorry. Plus, I suppose you say what in fact he did do. Yeah. Because when he found out, it took 9 months before anything occurred.
Yeah. I've got a million points on the facts. First of all, what happened here was exactly equivalent to what he was told was going to happen on the 28th of January 2008. The idea that he would have redeemed when he was told the equivalent had taken place seems extremely unlikely, particularly in the light of the finding in para 6.6 that I drew your attention to earlier this morning, which said he wasn't interested in the detail, he was only interested in the return. Secondly, he knows about leverage in October and does nothing. Thirdly, he knows the full picture in March 2009 and he does nothing. Fourthly, the snippets, and my Lord Hughes put to me what he said was the best snippet, and the snippet that my Lord Hughes put to me, which is in the record at 1888, was not one that in fact Mr. Black was relying on, because I couldn't find it until looking at footnote 105, and in fact it was Lord Hughes who'd found it, and it didn't in my... if you look at them all, and I invite you to look at them when you have an opportunity, they're all none of them saying I would redeem. They're all saying, oh, well, I would have had a chance to look at it, or I would have had a chance to see what was going on. Lots of other people weren't in leverage at the time.
Well, the main tenor of them seems to have been that he might have redeemed, and he doesn't put it higher than that, not in response to the discovery of what the managers were doing, but in response to the discovery that losses were being made across the markets, which were being magnified by leveraging for those who had leveraged portfolios.
But he
said he would have been concerned at continuing to leverage in circumstances where other people were pulling out of leveraging, although it's a bit late to be saying that after the losses have been incurred.
Yeah, I mean the big loss occurs after Lehman's in effect, which is the 15th of September. But He knows from the conversation in October, which the judge has found, that leverage is the big issue as between us and HSBC, and he gives no instructions about that. And the point that Lord Briggs made yesterday is equally significant. He's got an absolute right, subject to doing it on a quarter date and giving 60 days notice, to redeem a quarter of his investment at any time up to a year, and then he can redeem the rest of it after the year. So could I just take your lordship to look at?
I thought it was a third. I thought it was a third.
It's a third within the first year.
I may have wrongly said a quarter, but I think it was...
It's 166 million dirhams up to the end of the first year, and the whole amount in the second year. So he could have begun to redeem when he discovered about the leverage from October. He might have had to give 60 days notice, so it might have been at the end of the year. And he could have redeemed the whole amount from any time after the 4th of March.
What was the notice period?
60 days.
In both cases?
In both cases, yes.
Is the fundamental answer to the point raised by Lord Wilson not that in commercial litigation you don't get an infinite number of opportunities to get your case right? And he's gone to trial on a certain basis in relation to this, that there was a fraudulent conspiracy, effectively. He's failed on that basis. It's too late now to try to run a case on the basis of an innocent breach of contract. He hasn't pled that case at any stage. He hasn't led the evidence necessary to establish that case. And the court isn't going to have a second trial to see if he can do better on a different basis than the one he elected to run at trial.
Well, Lord, I mean, I accept all of that. I couldn't have put it better.
I mean, you can't run commercial litigation like that.
Exactly. And I mean, although there's lots of money involved here, these desperate attempts to create a new case at the last moment it's not just unfair, but exactly as Lord Reid says, you need a process whereby you've got to define what your case is, the judge decides it on the facts, and then what the appellate process involves is looking to see if the judge went wrong in law on the facts. It's not try at every level to get a new case, which is what's happening here. And there's no injustice in relation to this, because this is a piece of litigation that was fought, as you can see from the fact that we're here arguing points of this awfulness. This was a case that every single point was being taken. Just look at the pleadings. They're voluminous in the extreme. Look at the submissions that are made. There's over 100 pages at every stage of written submissions about at each stage. So that no point was left until. There's no unfairness. This is not a case about a lack of representation. This is a case of over-lawyering rather than under-lawyering. And it would be an absolute... It would be wrong to allow... I've drawn back from hyperbole. It would be so wrong, because Mr. Al-Sadik has been looking for years to get to a...
Okay, Lord Fulton.
Okay, right, sorry. Okay,
Let's leave it provisionally on the analysis of the just articulated by Lord Reid.
I'm happy to do that. My Lord, could I just say that you've been putting to me questions about innocent breach of F4, just a sort of microcosm of how you just can't be allowed to keep on changing your position. I went through with you yesterday that in the grounds of appeal to the Privy Council, the notice of appeal to the Privy Council, the issue was not an innocent breach of contract. It was expressly put on the basis that deceit leads to these conclusions. And if you just go to the case that is put in by the appellants, look at para 93 and 94. Page appeal bundle, page 2682. It's appeal bundle flag 61.
Yes.
The Court of Appeal was therefore wrong in failing to confirm the rescission ab initio of the SPA for fraudulent breach of F4. And then the next sentence is not. So it's plainly being put on a fraudulent basis. If one therefore goes to 2684 as well.
Yes, well, we see that. The
Summary of the reasons on which the argument is founded. The respondent's breach of F4 of the SPA was dishonest. The appellant was in consequence entitled to and did rescind the SPA ab initio.
Yes.
I mean, there are limits. This is a microcosm of what's going on the whole time, which is that the basis by which the thing is being advanced changes. One final point in relation to it. Lord Sumption asked Mr. Black, when do you say the loss would have started from? And the answer that was given, and Lord Briggs picked up the questioning later on, well, I say it would have been June 2008, June 2008 being the date on which the first FSP2, which would have shown the leverage on this hypothesis, would have been served. But we know from looking at what the position was at that time that in fact there was a tiny profit of 0.04% at that particular moment in relation to
I think it was I who asked, were there significant losses before October? And I was told there were.
Yes, there were.
But I wasn't entirely able this morning to see actually when they began.
Right at the end of the period, I think.
That's right, that's right. So the idea that, this is just a sort of another one of my million points. His case now, in answer to Lord Briggs and Lord Sumption, is I would have redeemed, Mr. Sadik would have redeemed upon receiving the May 2008 proper F4 document, which would have shown a profit of 0.04%. And you can get that, I don't ask you to turn it up, it's record 13, bundle 135055, is completely absurd. And it's just an indication that this whole case is holed beneath the waterline, factually. My Lords, those are my submissions in relation to loss and damage in relation to Wall Street. Unless there's any other point I can help your Lordships on, those are my submissions.
Thank you very much, Lord Falconer. Mr. Levy. Mr. Black.
Lord, I think I have about 20 minutes on the...
You do.
I'm replying.
I mean, is that going to be enough for you?
It will be enough.
Good. Well, let's see. Let's try and complete your reply within 20 minutes, and if you haven't, we'll review it.
I'm obliged. May I begin with... well, in fact, before where I was going to begin was in answer to my Lord Briggs's question yesterday, but may I actually begin in relation to the provenance of the documents that were handed up. And may I say that this is the last time that I shall ever do my learned friend a favour, because what I said yesterday was this, that I made certain very broad submissions that, number one, we had done a complete analysis of the judgment, and none of the oral argument was reflected in any points before the board. And I said I would share that analysis so that it could be seen that my broad submission of yesterday was supported if my learned friends wished to see it. And I also mentioned the fact that there were many interventions which didn't figure in the judgment, and I said we'd done an analysis. And again, I promised to share that overnight with my learned friends so that if they wish to take any issue with what I'd said by way of a broad submission yesterday, they could see the facts upon which it was based. That was the basis upon which those documents are supplied, and no other basis than that.
What do you want us to do with them?
I only gave them to you, my Lord, because I'd shared them with my friends.
Very well.
Thank you. That was it. And if my learned friends had any submissions to make upon them, they were free to make.
Thank you.
May I then begin where I was going to begin with answering the question that I said I'd like more time to consider from my Lord Briggs, and just for the record, it is in yesterday's transcript at page 98, lines 9 to 17. And I apologise for not answering it immediately, but I freely confess that I was slightly taken aback by the question, because the way that my Lord put it was I was submitting that the correct hypothetical case would be to ask what would have happened if Investcorp had not breached Clause A, but had breached Clause 4 in the way they did. And my Lord said, the Court of Appeal said you hadn't pleaded a case on that hypothesis. I think, with respect to what my Lord had in mind, and indeed I'm reinforced in the view by the exchange between my Lord and Lord Falconer this morning, was the finding of the Court of Appeal that we didn't have a case for innocent breach of F4.
Yes.
And contrary to my learned friend's interesting and characteristic submissions this morning, I don't say I have. I don't say that I am making a claim for damages for breach of F4 as an independent claim. My submission is that not that one takes account of a freestanding, unpleaded claim for damages in relation to the breach of F4. And indeed, in answer to my Lord Reed's point, I am not trying to resurrect a new case at appellate level. What we are submitting, whether the board finds it attractive or not, is that you take account of the fact of the breach of F4, which has been found and is not challenged by the respondent, in trying to see whether it is even possible to construct a counterfactual by which to test the damages claim for breaches of Clause A and unauthorised borrowing.
So you've got to be right on both.
I'm sorry, ma'am.
You've got to be right on both points.
Yes. I mean, my learned friend was effectively ignoring the breach of F4 in the construction of his counterfactual this morning, which is why I tried to produce that graphic yesterday, which was only on the basis that there was a breach of F4, and the alternatives were whether it was fraudulent or non-fraudulent. And the board, of course, gave its view after the short adjournment that it was not minded to find that it was fraudulent. So I'm left with that part of the counterfactual.
So you rely on the breach of F4
Yes.
only in the context of your allegation of a breach of Clause A.
Indeed. So
Thank
I
you.
do not seek to resurrect.
Does that mean in this document we can cross out the last box that says 3 plus 4 plus 5 plus 7? Because that seems to be no breach of Clause A, no unauthorised borrowing, no fraud, but a breach of Clause 4, which does seem to be a contractual claim based upon a breach of Clause 4. And you then identify 13, 14 and 15 as your losses. But I think I can put a line through that in light of what you just said, can I?
My Lord, I am not claiming damages based upon innocent breach of... There was a breach of Clause 4.
Yes.
It was not fraudulent. We are then trying to see what the counterfactual would be.
Well, I hope I've understood
the breaches of
I hope I've understood the table correctly. It's a very helpful table, if I may say so.
I think Lord Briggs may be right about this,
well, my
Mr. Black. If you look at 3,
Yes.
and you look at 4, and you look at 5, and you look at 7, that is an exposition about the result of a breach alone of F4.
Sorry, yes, I'm being a bit slow, forgive me. My learned
right.
junior is much faster than I am. And
Oh, I can cross that box out.
I can cross that box out.
Thank you.
Yes, thank you.
So, my Lord, the learned judge, again, and it's a point that my learned friend touched upon, said that essentially the respondents would make investments that, if they held until the 31st of December 2009, would involve the appellant in more loss. And my learned friend yesterday submitted to the board that finding, quote, took into account absolutely everything. That is clearly inaccurate with respect. When you read the judgment itself, not only, first of all, did he not disclose what he took into account at all within the judgment, but he went on at the end of the judgment to say that in any event those findings were incomplete and there were to be further arguments on the issue of damages. So my learned friend's submission in relation to that was, as we say, inaccurate. But the fundamental point that we're trying to make is that the learned judge's counterfactual ignores the breach of F4, as he indeed found. And one must therefore factor that in, and even if, on that basis, authorized investments were made, Mr. Al-Sadik was not would not have been told about them. And so you would have to construct about the leverage of the investments. So you'd have to construct a counterfactual where Investcorp invests in LDSF, but only, for example, tells Mr. Al-Sadik that he is invested in DSF or invests in SMFco, and invests in SMFco, but only shows him the unleveraged investments in the SMFs, which of course is what actually happened.
Why should you, in constructing a no-breach counterfactual, include in it an assumption of breach?
Because it's not the no-breach counterfactual for F4, it's the no-breach counterfactual for A. We are taking breach of F4 as read. It's an unappealed finding. So when you look at, if you're trying to isolate the loss which emanates from breach of Clause A, we say that you are bound to take into account the breach of Clause F4, because that's not the issue that is being examined.
Is there any authority for the proposition that when constructing a counterfactual to see what would have happened if a contract had been performed, you can do it on the basis of part performance, that is, performance of one obligation which it's been found that you breached, but still including in the counterfactual a breach of another obligation?
Well, my lord...
Of course the factual is that there was a breach of F4, but this is a counterfactual.
Yeah, well, it's the counterfactual in trying to isolate the breach of the loss of the breach that flows from Clause A. That's the point.
But why should one isolate it?
Why should one isolate it? Because one has to... Well, my lord, where I get to ultimately is this is a wholly unsatisfactory process when trying to use the counterfactuals at all, when you have two cooperating breaches, one of which is said to be a separate breach from the other and is found as a matter of fact. And the judge just didn't factor the second breach into his submissions at all. Where we get to is we say that, in fact, when you're trying to give some force to the interaction of the two breaches, it is really impossible to come up with a sensible counterfactual that isolates the losses consequent upon unauthorized investment or unauthorized borrowing. And one is, we say, thrown back onto what Lord Steyn called hardly an intellectually satisfying theory of causation. Can I just take you to that passage in his judgment, his speech, forgive me, in the Smith Court case? It's a section we didn't go to yesterday.
Yes, certainly.
And you'll find it in the core MS bundle at Authorities tab 102, page 4016.
Can I just ask you, in case there's a misunderstanding simply because of language here, you were saying yesterday that the loss had to be looked at holistically.
Yes, my lord.
And I would have thought in that event, rather than trying to isolate the consequences of a breach of Clause A, ignoring F4, rather you would be looking at what the consequences were of a breach of Clause A in the context of a concurrent breach of F4.
Well, that is what I try to do.
Yes.
And one ends up in ultimately what I respectfully submit is a very unsatisfactory position in trying to construct a counterfactual that gives effect there, because you have to do a very artificial exercise if one's doing that by saying...
I wonder if you do. I mean, you're saying that the breach of Clause 4 had the effect of making the consequences of the breach of Clause A worse than they would otherwise have been because your client didn't know what was going on.
He didn't know what was going on. Exactly, my lord, yes.
And so I would have thought the factual situation on your submission is a breach of Clause A, the consequences of which are aggravated by a concurrent breach of Clause F4. The counterfactual is all obligations duly performed.
Well, indeed, Lord Falconer concedes that. I just find it quite surprising that you don't want it.
Well, my lord, it's not that I don't want it. It's what I'm saying is it's quite a difficult counterfactual to consider when, in fact, what was being done in the circumstances was he was being told there was no leverage at all. My learned friend guffaws again, but we come back to the point that that he knew that all hedge funds involved leverage, and that the October meeting to which he refers, we know that he knows that hedge funds use leverage, but we're not talking about the hedge funds using leverage. We're eliding the idea of leveraging the investments in already leveraged hedge funds. And that's a distinction that's not made. And I'll come back to that, if I may, in a moment.
Well, all hedge funds don't use leverage. Some hedge funds
some
are
do,
leveraged. Some are simply engaged in arbitrage in different markets.
Yes.
Some are engaged in shorting stocks. There's an infinite variety of hedge fund strategies, of which leveraging is only one.
Yes. And Mr. Sadik knew that some of the hedge funds in which he invested used leverage because
More than that, that was the idea, that they were,
yes,
they were going to deliberately go for leveraged investments.
And indeed, the sheet, the information sheet that he was given for the Silverback single manager fund identified the leverage that it used. So one can't just simply say, take out of context the remark he made in October, well, everybody uses leverage, and say, well, therefore he knew that the leverage that was being applied to the totality of his portfolio was being applied. Because one has to remember two things. First of all, that it is an undisputed fact he didn't know the truth until 2009, and I'll come to the delay point that was made in a moment. So my learned friend can't have it both ways in the sense where we didn't actually tell him that the Blossom structure is being used or that his hedge funds were in fact being leveraged.
Technically, it may be an undisputed fact that he didn't know what was happening, but the findings of the judge show that he did expect to happen, subject to your second layer point, he did expect that what would happen was precisely what in fact did happen. It's hard to imagine that he would have been terribly surprised.
He did expect to be invested in leveraged hedge funds. That is correct. But he was also being told at that time, and when you look at the allocation tables, he was being told that actually his investments in those leveraged hedge funds were not themselves being leveraged. Now, that may have been an innocent misrepresentation to him, but that is exactly what he was being told in September, just before that meeting. He got, if you recollect the allocation table where the cash column had been deleted, which just showed that he was being told he was invested in DSF, he was invested in the various hedge funds, and he knew that those hedge funds use leverage, or some of them did. And he'd been disclosed that.
Now, Mr. Black, you want us to look at something in Smith New Court
Yes,
to the effect that all this is very unsatisfactory. Why is it so difficult for us to do what you say should be done? We are, for this purpose, assuming a breach of Clause A.
Yes.
So the counterfactual is there would have been no Blossom, there would have been no leverage at portfolio level.
Yes.
There would have been the sort of investments that were indicated in the investment proposal.
Yes.
So we assume that, and we assume that the underlying investments would have been duly disclosed in the monthly reports. If we assume, why can't we do that in terms of working out your loss or damage, if any?
My Lord, one can do that, but it doesn't represent what then, it doesn't give effect to the other breach of Clause F4. Yes, if you say that there would be no breach of A or F4, then of course that is that counterfactual situation.
Yes.
Yeah.
But what I'm saying...
That's the one you're being offered. That's the one you're being offered.
That's one I'm being offered by my learned friend because it helps, but it doesn't represent reality.
The counterfactual never does. It's a counterfactual.
But yes, but you have to take account of the fact that we say that there was also a breach of F4. It doesn't. It is a counterfactual that doesn't expose. The fact that there was an interaction between the two breaches.
But I mean, the F4 breach is entirely parasitic, in the way you're now putting your case, on the A breach. But what you're saying is that the A breach caused more damage than it would otherwise have done because it wasn't disclosed.
Yes.
So, I mean, on that footing, the F4 breach has no independent existence at all. It is simply a factor in the calculation of damages for breach of A.
Well, my Lord, that is pretty much the way I rely upon it. I'm sorry. Can we not have interruptions? Thank you. But my Lord, that's where I started by saying that I am not relying on F4 as an independent. Sorry, if my little friend would please. Thank you.
I agree with you, Mr. Black.
Yes.
Yes. Now, do we really need to look at this? If you want us to, we will.
My Lord, I would ask you to, for this reason, because it is my submission that I accept that you can absolve that you can take a counterfactual where F4 is not breached, but I do say that a counterfactual where F4 is breached is a difficult thing to achieve. But if you're trying to isolate what the loss under Clause A is, you have to try and do that in some way.
Now, whereabouts do we go?
We go to, in Lord Staine's judgment, at page 4016.
Yes.
And there is a section headed causation. It may be quicker if I just would ask the board briefly to read through that to themselves over to the end of that section on the next page.
We'll do it now.
Thank you, my Lord.
Yes. Well, whether we find the sort of difficulty in extreme circumstances they're referred to, we will see.
Yes.
But
well,
thank you.
My Lord, that's the thrust of my submission.
Yes, very well.
That because of the difficulty of constructing a counterfactual in this case, one is thrown onto what Lord Staine calls a less intellectually satisfying way of dealing with things. And it is our submission that here Investcorp made an unauthorized investment and used unauthorized borrowing, we say that common sense must indicate that Mr. Al-Sadik was disadvantaged in being unable to discover that breach and indeed mitigate the loss consequent on that breach. It is said against me that, well, did you raise the point with the judge so he could make findings upon it? And my learned friend made submissions yesterday to say that we did not. That is not correct. Can I give the references to the board to look at for themselves to see whether I'm right in my submission? Our written closing submissions to the judge, which are found in the core bundle, paragraph 86 of the closing submissions at page 856 in tab 12, and at paragraph 86 of the closing submissions, tab 12, page 856, paragraph 221.1.7, page 919, and in the...
we must get these references right. Core record you're talking about.
The core bundle, MS12, tab MS12, page 856,
okay.
paragraph 86.
Yes.
And paragraph 221.1.7 at page 919.
Yes.
And in the oral submissions, page 106, line 20 to 114, line 5, that's MS 35, pages 2282 to 2284. And it may just be helpful if, in order perhaps to give the board a flavour of that, can I take you to that section at page
82. Yes,
Yes.
2. So which bundle are we in?
We're in the core bundle,
So it's core record
Core
documents,
record.
volume 5.
the MS bundle, if that's...
They're both MS.
They're all MS.
Is it?
One is R, one is R, and one is MS. So we are... It is 35, it's MS 35, page 2282.
Yeah. Which starts, it's a mini bundle of transcript with page 105 as the first page exposed, is that right?
Yes, my lord.
Yeah.
Yeah.
And
You said MS 35. It's 36, isn't it?
Yes.
Yes.
so I'm sorry if that's a bad...
Okay. 2282. Yes, we've got it.
2282, that's where it starts. I should like just to direct the court's attention, if only to give you a flavour of what is a lengthy exchange between myself and the learned judge, really on internal page 111, which is on the next page at 2283. And again, may I just ask the board now just to read what I was saying to the learned
Yes, we
judge.
will, Mr. Black. Yes.
I'm sorry. My lord, I'm just told I gave you the wrong reference to the paragraph 86 of the closing a moment
Yes.
ago. It should have been. It's page 836, is it not 856? Yes. It's page 836, not 856. I apologise for that.
Very well.
Thank you.
Thank you.
But, my lord, just as I say, to give a flavour of the whole of that exchange, which I do ask the board to read if they'd be so kind. The thrust of submission was that in terms of causation, the structure adopted, i.e. unauthorized investment, unauthorized borrowing, and also the breach of F4 prevented the appellant from discovering the breaches. And so I think the case was being put yesterday, that the judge was not being asked to consider that, and we say that he very much was in the closing submissions, and it's incorrect to suggest the judge was not invited to consider the issue.
Very well.
My Lord, Lord Falconer suggested that we had not pleaded loss of opportunity to rescind or redeem, and that sounded in damages, and Lord Falconer was correct about that. That's because the case has never been put that way. The damages case has always been put on the basis that the use of leverage by Blossom reduced the net asset value of Charlotte by more than it would have been reduced if the unauthorized borrowing had not been used. And that's precisely the way it's pleaded in the original statement of claim, but also right through to the re-amended statement of claim at paragraph 30.2, which the board will find MS tab 7 at page 380.
I mean, it may have been pleaded that way, but the judge didn't accept that, did he?
No. Well, no, he found that there wasn't an unauthorized use of leverage.
Well, he did, but he also found that there would be no losses sustained as a result of the route taken, even if the route was in breach.
He found that if a particular route was taken and it was maintained to the 31st of December of 2009, the losses would have been greater. But he did not consider, and you'll see in the passage that I've cited to you from the closing submissions that I was making the submissions, that was an incomplete and bad assumption that one would keep the tap on full for that entire period. So that was a point that was before the judge. And indeed, I also drew the board's attention yesterday to the very evidence where they were starting to deleverage in October. So it was a finding that he neither explained nor in fact is supported by the evidence, but that's absolutely right. That's how he based his counterfactual. And so we say that the opportunity to curtail or mitigate the use of the leverage is a step in the causation of loss and is not a freestanding head of claim. And so there is a double breach. Investcorp breaches the SPA, then breaches it again with the effect of making it impossible for Mr. Al-Sadik to discover the first breach and stop the unauthorized leverage so as to mitigate the loss that he is suffering. And that is the way that we put the case, not as has been characterized by my learned friend. And we say that when he finally did discover the truth, he did indeed redeem, and the loss consequent on the unauthorized investment and borrowing was crystallized. Now, the point the board made, came from the board yesterday, and indeed again today, is that Mr. Al-Sadik waited before he redeemed. There is a very considerable volume of correspondence in the record while Mr. Al-Sadik and his lawyers tried to find out what had happened.
But he
Let us
knew
not
what
forget.
had happened in March. You accepted that.
He found out about Blossom, but let us not also forget that he'd had the deceitful letter on the 8th of March saying that this was all justified because we had that power.
It was all authorized.
Authorized, forgive me, I used the wrong. It was all authorized because we had the power in the deceitful investment management agreement. And there was a great deal of correspondence thereafter seeking further documents. And again, for the note.
I mean, I can quite understand how that may extend the period before he might be expected to accept a repudiation
Yes.
for breach. But I don't understand why that should have had any effect on his right to redeem.
Well, if one reads the correspondence, what he does is ultimately he claims that he's entitled to all his money back.
Yes, I know.
For rescission. And the whole of that correspondence stretches from the 10th of March all the way through to the 10th of December, from record page 637 through to page 6461. And the ultimate position is, I want all my money back, I am rescinding for fraud, but without prejudice to my position, I redeem. And that's where the exchange between the lawyers ended up. But
the question is, if he was someone who would have got out of a leveraged position if he'd known about it.
Sorry, forgive me, I didn't.
The question is, if he was someone who would have got out of the portfolio leveraged position if and once he knew about it, regardless whether it was in breach, why didn't he do it in March?
Well, in fact, the market was rising. In fact, the damages, any damages to which he was entitled were reduced by the delay rather than...
If the market was rising, that tends to support the case against you.
I'm sorry, in what way, my lord?
Because evidently he was, on that footing, completely satisfied with the existing situation and wished to get more benefit from the leverage.
Well, my lord, with respect, that pays no attention to what was going on at that time. He was alleging fraud against them at that time through his lawyers. He was seeking to rescind for what he was alleging was a fraudulent misrepresentation, which took up that period. He gave them a time limit to repay his 500 million dirhams. They did not repay his 500 million dirhams. He said, in that case, without prejudice to my claim for rescission ab initio, I redeem. And that's the sequence of events that took place there. And I say one cannot then draw a conclusion that he was delaying because he was satisfied with what was happening. He was alleging a case of fraud against the bank and seeking rescission ab initio, which of course was denied.
Mr. Black, your reply has gone on now for over half an hour.
I'm sorry.
When nobody is complaining in the slightest. But would you think it appropriate to draw the threads together?
Yes, my lord, I probably have about 5 minutes.
Very well.
I've got 6327. Can you leave me alone? So, I do draw it together in terms of what I say is the common sense loss then, and I'm only addressing loss. The experts have agreed, Mr. Matthews, scenarios 3A and 3B that represent the loss attributable on the exclusion of leverage from the underlying funds. We say that either of those two analyses would amount to the common sense indication of the loss from the unauthorized application of leverage, because the experts have there tried to isolate the loss attributable purely to breach of Clause A, if I can call it that, and make allowance for the losses in the market that would have been sustained in any event. Finally, can I just end really where I started my reply, I do wish that time would allow me to correct a number of ways in which Lord Falconer mischaracterized my case for me in order to set up an Aunt Sally. But I'm going to content myself, if I may, just with one, which was his very first yesterday. He began his submissions by claiming that I accepted in my closing speech that the investment which both parties contemplated was one which would involve leveraging the appellant's equity investment. And he cited a passage from our closing submissions that actually says the precise opposite of that. And I hope that when the board comes to read it at page MS 753, you will see that. We were saying exactly what I'm saying now, is that there wasn't an authority to leverage. We accepted that there was to be an investment in leveraged funds, but I did not accept, and I do not accept to this very day, that it is common ground that his equity was going to be leveraged in that way.
I haven't understood you to accept that at all.
Well, unless I can assist the board further, my lord, those are my submissions.
Let me ask my colleagues. It seems not. Mr. Black, thank you very much indeed.
Thank you, Lord.
Well, an enormous amount of work has gone into the preparation of this appeal, not just by the full council before us, but by a number of solicitors on each side. And they've done a magnificent job, and we'll reserve our advice to Her Majesty now. Thank you.